Morning, everybody. Thank you very much for joining us today. My name is Pauline Chung. I'm the Director of Communications and Marketing for the San Mateo Area Chamber of Commerce. Cheryl Angeles, the CEO, was unable to join us this morning. She's on her way to the office, so she might check in while we're doing this. I want to welcome Jeffrey Windsor, one of our chamber members and a BRN member as well. He will be speaking about business interruption, leases, and the courts. Jeffrey's a civil litigation attorney and a mediator. He practices throughout the San Francisco Bay Area and Hawaii as well. He specializes in business, commercial, and real estate litigation and counsels entrepreneurs, small businesses, and middle market companies. He has nearly 20 years of experience representing his clients. So I'm going to turn it over to Jeffrey, and feel free to put your questions in the chat. I will monitor that. But I ask that you stay muted through his presentation, and we have time for Q&A at the end. Thank you very much.
Good morning, everyone. Thank you for joining me for this. First, let me say, and I hope everyone is healthy, physically and mentally. These are extraordinary times, and now that we're in the midst of an election season, we need to be concerned about wildfires and smoke, and parents, kids, teachers, and students alike are learning how to teach and learn remotely, so it can be stressful. I suggest taking a lot of deep breaths and try to make healthy behavior your default activities. I'm going to try to share my screen here. So I think that's up. Pauline, can you see that? Okay, thank you. So second, I prepared a good amount of material here, and I'm going to try to get through as much of this as possible. I should say, excuse me, at the outset, that what I'm imparting to you here is not legal advice and should not be construed as such. Pardon me, however, I will be discussing certain areas of the law that I think are going to be important for individuals, businesses, and attorneys for some time to come. You should also be aware that a lot of what I'm going to be discussing is in a bit of state of flux. The laws, orders, and regulations regarding these topics have been changing monthly and weekly. If you have any questions about anything discussed here today, I'm happy to talk with you after this meeting, or I encourage you to contact your attorney if you already have one. I believe this is being recorded, so I think you'll be able to go back and reference items that I'm going to be talking about, and it's all public record in one format or another. But again, if you'd like to talk about it, I'll answer some questions at the end, and I'll give you my contact information. Excuse me. Now, I'll start with some of the bad news, and hopefully by the end of my presentation, you'll hear something that you'll think positive or at least helpful. First, regarding business interruption insurance. There are some small businesses here in San Mateo and businesses large and small all over the country that are considering or actively pursuing claims for lost profits or expenses under their business interruption insurance policies. If you are such a business owner, the first thing you or your attorney should do is carefully read your policy. The specific language of the policy matters. For businesses, news regarding court decisions on whether there is coverage under their policies is fairly grim. Courts all over the country, and here in California, are trending toward not finding coverage pursuant to the policy language. First, insurance carriers are generally denying such claims. And in all risk policies versus stated peril or specific risk policies, in looking at the threshold question of whether there is any physical damage to the property, courts are holding that because the virus hasn't caused physical damage to the property, there isn't coverage. Also, in looking at the specific perils or risks that business interruption insurance usually covers, coverage for an epidemic, pandemic, or communicable disease is often not specifically called out. Those policies are being strictly construed, and courts are generally deciding there isn't coverage. Excuse me. The policy may also include within it, or as an endorsement, civil authority coverage. This is coverage for lost business income due to suspending the business when access is prohibited by order of a civil authority. So let's say there was a fire nearby and an area needed to be evacuated. If that resulted in a business being closed, that may qualify under the civil authority coverage. Here, the argument is being made that health orders are causing businesses to be closed, primarily because they're considered non-essential, or there is a prohibition on the number of people that can enter at a time. These arguments are still not getting past the threshold issue that there isn't direct physical loss or physical damage. Courts are looking for some kind of tangible damage or loss, excuse me, something affecting the physical integrity of the property, such as a fire or flood. Without this tangible damage, generally, they are not finding coverage. In a recent case out of Monterey, the court held that the Inns by the Sea in Carmel had not and could not allege that its business income loss was caused by direct physical loss or damage to the property. Another issue that's arising in these cases is that the policies often have a virus, bacteria, or communicable disease exclusion. That is, in many policies, even if there could be an argument made that the coronavirus somehow attaches to the physical property in the establishment, which at least one court has upheld, there is often an exclusion in the policy that precludes coverage for losses caused by a virus or other microorganism that causes illness or disease. That was part of the reason that a court in Texas sided with State Farm Lloyd's and denied coverage to a barber shop. The policy was written broadly enough, including the exclusion, to exclude coverage. Although the barber shop was closed because of the local health order, the reason for the health order was the coronavirus, something specifically excluded by the policy. If you're a small business and you've made such a claim and are getting this kind of pushback, you're not alone. And it's generally what is happening in the industry right now. There are courts that have allowed cases to proceed on allegations that the property was made unsafe or unusable, but those are the exceptions. I've read that the insurance industry projects $107 billion in pandemic-related losses, and they're trying to stem their own bleeding as much as possible. Where the language of the policy gives them that protection, the ability to deny coverage, they're going to assert it. And for the time being, courts are upholding those decisions. Again, you or your attorney needs to carefully read your policy for its grant of coverage and all possible exclusions. Ultimately, this may be something that our legislature needs to address. I'm reasonably confident in saying that I don't think Congress is going to look at it anytime before November. Is all hope lost then? No, because our local legislators and courts are at least giving businesses and consumers some time to persevere and press on. Now, a brief update, excuse me, an overview of where things stand regarding landlord-tenant issues, both residential and commercial. Again, regarding this issue, whether it's commercial or residential property, and depending on where you're located, you should talk with an attorney. If you're looking at the non-payment of rent or a potential eviction on either side, excuse me. The law and regulations depend on where you're located, including down to the city. This includes when evictions can take place, how much notice is required, how much can or is required to be paid, and when. The statutes and orders regarding these issues are in a near constant state of flux, though we're getting some longer-term guidance at the state level that many local municipalities are following. The first place I'll start is with regard to the San Mateo County moratorium on residential evictions, which was issued back on March 24th. If you are a property owner with rental units, I'm sure that you know this. As part of that order, the Board of Supervisors adopted an emergency regulation that placed a countywide moratorium on evictions for residential units for the non-payment of rent by tenants that were directly impacted by the coronavirus and certain no-fault causes unless the eviction was necessary for health and safety reasons. That moratorium was extended through subsequent emergency regulations to August 31st, and that moratorium is now expired. Somewhat related to this, the Judicial Council of California had also issued an emergency order on April 6th related to evictions and unlawful detainer actions. The Judicial Council is the governing body of the state courts and is led by our Chief Justice of the California Supreme Court, Tani Cantil Sakaue. The Judicial Council issued an emergency rule that, among other things, suspended the issuance of a summons in unlawful detainer actions unless the court found there was a health and safety reason to issue it. The summons, in essence, starts an action, makes a person or business aware that they're being sued or called as a witness or as a juror, which we'll talk about in a bit. The suspension by the Judicial Council essentially prevented the filing and pursuit of UD actions. The rules also prevented the entry of a default or default judgment in UD cases and mandated at least a 60-day continuance of UD trials. Those were statewide rules. Those rules also expired on August 31st. In a manner of speaking, the Judicial Council was telling the state legislature and governor, we're going to take emergency action to further protect tenants temporarily, but you need to address this problem. Now, here in San Mateo County, that has been extended somewhat. Rightfully, local courts have discretion to set their own rules, and most every court has as it relates to the current crisis. To that end, because of the pandemic and the demands that it has placed on our court, especially in trying to address safety issues, it has, in essence, extended some of the rules and continuances originally put in place by the Judicial Council. Here in San Mateo County, they have been extended to October 2nd, the end of this week. So no default can be entered in a UD proceeding, no summons will be issued on a complaint in a UD case, no writ of possession issued. And UD trials that are currently set are continued, and future trials will likely not be heard for another 2 months, at least. Now, the state of California recently enacted legislation to begin addressing this problem, at least on a statewide level. This is a new law intended to protect tenants from evictions due to COVID-19 related back rent through February 1st, 2021. It applies to all residential rental tenants in California. It provides protection from eviction and additional time to pay rent for COVID-19 related financial distress, and that can include lost income, increased out-of-pocket expenses related to performing essential work during the pandemic, increased expenses directly related to the health impacts, childcare responsibilities, costs, or other things that have directly affected tenants' income as a result of COVID-19. There are, for these COVID-19 related hardships, these are four hardships that accrue rather between excuse me, March 1st, 2020 to January 31st of next year. There are basically two periods to which these hardships and the related obligations apply. March 1st of 2020 to August 31st, that's considered the protected period, and September 1st through January 31st of next year, in essence, a transition period. Tenants are going to need to sign a declaration of an inability to pay all or part of the rent during both periods. And for hardships that are claimed between September 1st and January 31st of next year, the tenant must pay at least 25% of their missed rent payments by January 31st. And ultimately, tenants are responsible for paying any unpaid amounts of rent. The rent isn't forgiven, it's just deferred. Landlords can begin to recover this debt on March 1st, 2021. And such cases will be handled in small claims courts which will have expanded jurisdiction until February 2025. The new law extends the notice period for non-payment of rent from 3 to 15 days to give the tenant additional time to respond to the landlord's notice to pay rent or quit. It requires landlords to provide the hardship declaration form in the same language that the lease was negotiated, be it Spanish, Chinese, Tagalog. It requires landlords to provide tenants certain notices detailing their rights under the Act, and the notices that the landlords are to provide can depend on the period of time for which rent is not paid. One of those notices, one of those required notices is tomorrow. It's very important that a landlord look into and comply with these notice issues. The California Department of Real Estate has created a website that discusses these notice requirements, resources, and forms that can be used. The Act also protects tenants against being evicted for just cause if it's shown that the landlord is really evicting the tenant for COVID-19 related non-payment of rent. And existing local ordinances generally remain in place until they expire, and future local action cannot undermine this Act's framework. Again, the back rent will become consumer debt. Those cases will be handled in small claims courts, and all of the notice language is provided in the bill and on the DRE website. I've provided the address here. Some of you may have heard about the federal eviction moratorium put in place pursuant to an order by the CDC. This moratorium is effective from September 4th through December 31st. It doesn't relieve any individual of any obligation to pay rent. To invoke the CDC's order, tenants must provide an executed copy of the declaration form to their landlord. Tenants need to be able to affirm their qualifications under the order, including income qualifications, that there is a susceptibility to homelessness or crowded shelters, and that they've sought government help for paying rent. Generally, it applies where state measures are weaker. However, as you can probably tell, California's new state law is more protective of tenants. Now, regarding commercial evictions. Most recently, literally last week, Governor Newsom issued an executive order that extends local jurisdiction's authority to maintain a moratorium on commercial evictions until the end of March 2021. Whether there is such a moratorium is more often decided by the city. San Mateo County had one that included the unincorporated areas of the county, and then each city had jurisdiction on their own whether to implement one. The city of San Mateo has one that extends through until tomorrow. And to my knowledge, thus far, that has not been extended. I believe the same is true for San Francisco, and in Santa Clara County, it appears the moratorium was extended until November 30th. Another very recently enacted program that small residential rental property owners will want to know about here in San Mateo County is an assistance program put in place by the county. A small residential landlord can apply for grants up to $6,000 for rental units that are located in the county, where the tenants are renting residential units for 30 days or more, so no Airbnbs, where the owner can show lost income between April 1st through August 31st, and other qualifying criteria. The owner also must own 10 or fewer units in San Mateo County. The owner must have earned less than $400,000 annual gross rental income in 2018 and 2019, and the owner must reside and rent the units in San Mateo County. So if you or someone that you know is a landlord in San Mateo County and they have discharged past rent or lost rental income as a result of the pandemic, they may want to apply for a grant under this program to try to recover some of that lost income. Now, regarding the courts and how some of what I've described above can affect property owners or tenants as these issues turn into disputes and possibly litigation, the courts are open and are managing their caseloads as best as they can. San Mateo County Superior Court reopened at the end of May and has been operating since. The first thing that you should keep in mind with San Mateo Court, and I think most courts, is that criminal matters, family law matters where there's the potential for domestic violence and similar types of cases are being given priority. There's a constitutional right to a speedy trial in criminal matters, and the courts are abiding by that as best as they can under the circumstances. People's health and safety are the primary considerations, so they're taking that into account when it comes to spacing, the wearing of masks, and other measures before entering public facilities. As it relates to UD actions, they had been suspended. The last order that I reviewed indicates that things will change at the end of the week. As I said earlier, until then, no summons will be issued on a complaint and an unlawful detainer, no writ of possession will be issued, and UD trials that are currently set are continued to October 12th at the earliest, and future trials for which a request to set for trial had already been filed will likely not be heard for another 2 months. Civil cases are going out for trial, but again, those are taking longer. Keep in mind, there were many cases set for trial before and during the closures, and now the court is trying to catch up with those. Anticipate that every part of the process is going to take longer, and that includes the time to pick a jury. The number of courtrooms that can be used are limited because of spacing requirements, and not only in the courtrooms, but even in how many people can get into an elevator to get up to the courtrooms on the floors above the second floor. I know that people are now being called for jury duty to the San Mateo Events Center. So the court and the county are clearly exploring every option that they can to expedite the judicial process in a safe way. And from what I read, experience, and hear from colleagues, this is how it's going in all of the courts around the Bay Area. People are working their hardest under strained conditions, but you should expect things to take longer, especially civil actions. The key word in all of this is patience, I think. Be patient. Personally, I don't think there will be a vaccine in the next few months, and even if there is, many will be reluctant to take it, or at least the first one. And even then, public places may start requiring proof that you have before allowing you to enter. You can't even fly to Hawaii right now without anticipating a 14-day quarantine. I think I read recently that New York is going to have its own vetting process regarding a vaccine in light of issues that have recently arisen regarding the CDC and FDA. If you or someone you know, another small business owner, a restaurant owner, a commercial landlord or tenant is in this kind of situation, encourage them to try to work it out. If they can't, an option is mediation, and I can talk with you separately about that. There's also arbitration, but that can take a while and eat up the rent or other expenses that the dispute is about. So if anybody wants to, I'm happy to discuss these options or about anything else that I've already talked about. And thank you for listening.
Thank you, Jeff. Chat window. No questions in the chat. So the audience, please feel free to unmute and ask your questions or provide your comments.
Good morning, Jeff. Thank you for the presentation. I really appreciate it. I do have a question. I have a client that actually is in the process of re-signing a new lease. And one thing that we requested is to, one, adjust the rent because we don't know what's going on, and to add a force majeure clause to the lease. Can you speak a little bit about that? And, you know, what landlord's responsibilities are if we do request something like that, and how to most effectively initiate that change in the lease?
I'll speak to possibly the second point, and that is there isn't necessarily a responsibility to include a force majeure provision. It's a good idea, especially for a tenant, I think, in these times, and you want it to be as more or less as expansive as possible. Mm-hmm. One of the things to remember about force majeure clauses is that they also can be strictly construed. And so if there is something that takes place that is not included as a possible event in a force majeure provision, then you run the risk of a court looking at it and saying, okay, you did not include a pandemic or a riot or a terrorist attack in your force majeure provision. Mm-hmm. So it does not need to be enforced. So that might be an important point for your client going forward.
Pauline?
Yes.
I have a follow-on comment to Silas's timely and pertinent question to Jeffrey. I perhaps like Silas, spend a fair amount of my time representing both landlords and tenants in renegotiating current leases. And perhaps like most, if not all of the attendees, I don't own my office building, so I'm paying rent as well. So my advice pertains to me as well as everyone else, and that is whatever deal gets agreed upon by the parties, and this pertains to both landlords and tenants, whether it's rent abatement, rent deferral, oftentimes tied to a lease extension as a quid pro quo, it is essential that all the parties to that renegotiated deal get if not the pre-approval, which is ideal, then the simultaneous approval of the lender, because 99% of properties, that are not in distressed areas have a provision in the lending document requiring the approval of the lender. So whatever modification to that lease occurs, and even a minor rent adjustment, 2 months abatement, 2 months free rent, a combination, triggers that clause. So I'm admonishing my clients, whether it's landlord or tenant, and not in the same transaction, mind you, to get that, or else you're proceeding at your own peril. That the deal that you thought was, now in place is subject to being nixed 3 months, 6 months, or a year from now. Landlord and people are doing this in good faith. I mean, they're not trying to conceal it from the lender. They may times just not be aware that that's required. So it's it's very perilous out there if you're doing that without the lender's approval.
That's a very good point.